just about the brief that I've given. Uh, Basically, the guiding legal instrument that the Department of Development Control anchors on to carry out their activities is the Urban and Regional Planning Law of 1992, and as amended in 2004, that is Cap 138, Laws of the Federation of Nigeria. Uh, Starting from section 27 of that law down, talks about the activities of development control. Uh, the law says all developments must seek planning approval from the control department. All. And section 30 even made it specifically clear that government projects as well, government developments must also seek approval. So that is the beginning of the journey. Uh, I would say 60 to 65% of demolitions happen because people either ignore the law or they seek advice from those who are also ignorant about the law. So if you start a project without an approval, a development control site officer will come to the site and seek that you show your building approval. If you do not have it, he will mark your building and stop the work from continuing. So the first notice is going to issue to you is called a stop work order. And it is for 21 days. And it's apart from the marking you see on the wall, the order is also in writing. So a paper is also issued to you, the developer. You have 21 days to come to the control department and give reasons why you have started this construction. Probably you will say you got land from departments of land, so it is your property. Fine. What is the land use assigned for that plot that was given to you? What kind of building? Are you following the regulations that the control department have given to the public as what we have in the public space, the FCT development control regulations? Well, we are still using the 2007 version of that, even though we will soon release a newer version. But it is the public space for all developers to know the regulations that are attached to all plots allocated in the Federal Capital Territory. If you show sign of ignorance, you will be given the guidelines and be given time to start abiding. Meanwhile, your work must stop at whatever level you are until you fall in line with these regulations and make the necessary corrections. However, if the construction has reached a certain level and the land use is in line with what you are constructing, and perhaps the regulations concerning setbacks are not too obvious or too harmful to the neighborhood in which you're developing, you might be excused and be given what we call as built approval, which attracts a penalty. Your building may be allowed and be issued an as built approval. But if you have faulted too much, such that whatever you are doing there, whatever you are constructing, is going to impact negatively on the neighborhood. You will be asked to discontinue the construction. You will be given amends to make on the construction. And if they are such that even amendments will not work, you will be served a quit notice. After a quit notice, you are expected to vacate the site. Assuming the plot is yours. If you do not vacate the site, the control department will enforce a removal by issuing you a demolition notice. If the control department remove the building on their own, you will be charged the cost of that removal. So we have a stop work notice, we have a quit notice after 21 days. After another 21 days, we have a demolition notice. During this time, you are expected to make corrections to wherever you are failing in abiding by the law. It is when you show complacency or stubbornness, you are recalcitrant, then demolition will be carried out on your property. This is one part. The other part is overriding public interest. Assuming the property is even yours, and even if the control department had issued you an earlier approval, but a need arises for your building to be removed, either because there is need for a road, there is need for the city to open up a waterway due to some circumstances, there is need for some kind of public facility to be expanded or to be established where your plot is. Any kind of overriding public interest, your plot will be revoked. The approval given to you will be revoked. And the government will carry on with the project that will benefit the city. So that is the second stage where your building can be demolished. The third one is for safety, either your own safety or the safety of the people around you. If, for instance, you have an approved building and it begins to show structural failure or structural weakness, you will be informed and you'll be given time to correct those failures, failing which the department will take action. They will vacate you from the building and demolish it. Sometimes the plot will be revoked if the owner of the plot showed sign of irresponsibility. But if the owner of the plot shows responsibility, but for one reason or the other, he or she is not able to remove the building on his own, he will be asked to redevelop in line with the regulations. Now, the one that has become rampant recently is that of people building on land that do not belong to them. It still falls under the first category of removals, where you are building against the law, because When you submit your documents for approval, the first thing they check is whether or not the land belongs to you. So they go ahead and develop on lands that do not belong to them, either by outrightly grabbing the land or by cloning original documents, which can evade the scrutiny of the department, of the control department. So at first instance, you might escape the scrutiny, the verification process of identifying the land. But afterwards, it could be identified that the documents that is submitted to the control department is fake. Whatever development that you have on that property is marked for removal, and it will be removed. So sometimes you see large estates that have been built on fake landed titles, or they're just being constructed without approval, ignorance of the law, or undermining the Department of Development Control. So you see these instances. These are just the three basic categories of instances where you have buildings being demolished. However, there are instances in between that are neither here or there. But basically, these are the three reasons why buildings are demolished. Thank you very much.
Thank you very much for that information. That is so powerful. You know, a lot of people don't get this information, are not in a public space, so they don't get to understand. I think a lot of people think that it's because of government interests, selfishness, or maybe influence that cause demolitions. So thank you very much for that insightful information, and thank you.
Before I ask my question, I want to quickly go to the first presentation as made by Mr. Patrick concerning why reasons why a particular property can be demolished. One of it, the second point, was that if it is for public interest or public safety, as the case may be, but you did not add if there was going to be compensation or reallocation to the original owner of such property if it is demolished for the sake of public interest. So I would like to know, is there a remedy, is there compensation, is there a way of alleviating the pain of anybody whose property is demolished under that ground?
Can you hear me? Okay, good. So in the first category, where a developer is building against regulation, against the law, and after being informed and guided, he's showing signs of complacency or he's being recalcitrant, the demolition will be carried out at the expense of the owner of the property. So there's no compensation. On the second category, where the demolition is for overriding public interest, the government will reallocate another property, another plot to that person, and he will be given building approval free of charge. And of course, he'll be compensated to develop according to the evaluation of the property that is being that was removed. So there is compensation if demolition takes place for overriding public interest. The third category is if an existing building shows structural failure, or for one other reason. If it is structural failure caused by fault in construction, the government is indemnified. That is, the responsibility is on the developer because he did not use correct building materials, or he did not employ a professional to do the construction for them. So he will carry the cost of removal and reconstruction. However, if the structural failure is caused by natural occurrence, maybe there's an earth tremor or some kind of unforeseen circumstance. For instance, a bomb. We're at war and a bomb falls on the city. Some structures will be affected and they will fail structurally. The UN Charter provides that all such removals or all such structures are supposed to be compensated for by the government. So on this last part, there are two parts to it. If the fault is caused by the owner of the property, no compensation. If the fault is caused by some natural disaster or some unforeseen circumstance that affects the entire neighborhood or town, the government will pay compensation to make sure that the person is housed appropriately, especially if the construction is a residential building. Thank you very much.
On behalf of Urbanice firm, I sincerely appreciate everyone. Thank you all.